Hello, this is Philip Nan from White Collar Legal, and this is a presentation on contract law, the basics. What is covered by this presentation is what is a contract, and we'll go through offer, acceptance, certainty, consideration, intention to create legal relations. We'll also go through privity of contract, varying a contract. Every day people experience contracts, and some examples include getting on the bus and paying for the ticket, and the contract is made is that the bus driver will take you somewhere in exchange for payment. Another example is where you go to the shop and buy a chocolate bar. The contract is your payment in exchange for the chocolate bar. Or you go to a sports centre or a gym, you pay to use the gym, and the gym owner allows you to use the gym equipment in exchange for that payment. The first part of a contract is the offer. There are various types of offer. There's an express offer, implied offers, unilateral offers. There's also a thing called invitations to treat, which are not offers. So an express offer kind of looks like this. I will sell you this item for £500. An implied offer could be you take an item to a till in a shop or a supermarket, and by you taking that item to the till, you're implying that you want to offer to buy it. Unilateral offers is an offer where someone makes an offer for anyone to do something. And there's a famous case of Carlisle and Carbolic Smugball from 1893 which demonstrates this. In that case, the Carbolic Smugball Company offered or put out an advert in the newspaper that if someone got flu and used their product, they would pay them £100. Their product was a prototype, it was a test system which could cure them from flu. That's the offer. So the offer was, use our product, and if you don't recover from the flu, we'll pay you £100. That's the offer. We'll come on to that case again when we deal with acceptance. Invitations to treat are not offers, and you'll find invitations to treat like in adverts. You'll see an advert in the newspaper, I've got something for sale, £500 or nearest offer. Auctions, you also get invitations to treat where the auctioneer invites bidders to place an offer. You've also got shop windows and shelves. Supermarkets, when they have their food and veg on the shelves, they are not actually making offers. That is essentially an invitation to treat. It's an invite to take the product to the till and make an offer to buy it. So the price you see on the shelf is not always the price you pay. Although if you are a consumer, you are bound by the Consumer Rights Act, and essentially the price is what you actually pay in typical circumstances. Dealing with acceptance, the acceptance can be express. It can be accepted by action or conduct. And we'll also go through the acceptance of a unilateral offer. Express acceptance looks like this. I offer to sell you the item for £500. You tell me you agree. Simple as. It's express. It's something that you're telling me that you're going to do. Action by conduct. In a shop, you take the item to the till. That's your offer to buy. The shopkeeper tells you the price, and that's his offer to sell. You don't say anything but give the money. That's an acceptance. Other sort of acceptances by conduct is that you receive offers and then you just carry out the task at hand. Perfect example: acceptance of a unilateral offer. Like, you carry out the conditions set by the person making the offer. Back onto our case of the carbolic smoke ball. Mrs. Carlyle saw the advert, she suffered from flu, she bought the goods, tested it and didn't recover. She then tried to claim £100 and the court said yes, you can have it. You accepted an offer that had been made to the whole of the world. It's an acceptance, it's a binding contract. In all circumstances, there must be some action taken to accept an offer. Acceptance by silence or inaction does not work. Essentially, the general rule is an acceptance must be communicated, or must be shown to be communicated, or some action taken. So silence doesn't work. In every contract there should be, or there must be in most cases, certainty. The terms must be certain. You must know what the terms are. For example, you must know what you're paying for and what you are getting as a result. Certainty is a complex subject, and as this is a basic presentation, we won't go any more into it. Every contract, every binding contract, must have consideration. And consideration is essentially something of value which is gained or lost by all the parties to a contract. Take our shop scenario. The customer gives away 50p and the shopkeeper gains the 50p. The customer gains the chocolate bar, the shopkeeper loses the chocolate bar. That is really basic. But what's most important with consideration, it only has to be sufficient. It doesn't have to be adequate, it just simply has to be something of value, whether or not it's value for money. If I paid a penny for the chocolate bar, that would still be a binding contract. Two old cases that are still good law today: Thomas and Thomas, 1842, where £1 a year was charged for rent on a house, and that was held to be valid consideration and a binding contract. There's also the case of Chappell and Nestle, 1960, where Nestle offered free chocolate wrappers, free of their chocolate wrappers to customers for a piece of music, a record, and that was held to be valid as well. Consideration must not be something in the past, and there are some exceptions to this which we won't go into in detail. But for example, last week I cleaned your car, today I come to you for payment. Can I have it? No, I can't. There's no contract. There probably wasn't even an offer or acceptance. Another type of consideration which isn't consideration, there must not be an ongoing obligation. For example, if I owe you £100 and I offer to pay you £50 instead, can that be a binding contract? No, absolutely not. But as I said above, consideration must be sufficient. So if I say I offered you £50 and clean your car to satisfy the debt, that could be classed as good consideration and a binding contract. And there is something of value in cleaning your car. Maybe not be worth £50, but it's certainly sufficient consideration. Every contract must have an intention to create legal relations. There is a lot of higher court authority and cases that deal with this, but the basic principle deals with two scenarios. In family and social agreements, i.e. husband and wife, brother and sister, friends, there's no intention. to create a legal relationship. That's the presumption in law. In commercial contracts there's always an intention, and that's presumed in law as well. But these presumptions are rebuttable, and to rebut them there must be evidence to rebut them, evidence to show the contrary. So for example, in family or social agreements there might be something in writing, or an exchange of substantial sums of money, or perhaps land. So you might hear of family members actually writing down the terms of a loan, for example, which is a case that I actually dealt with last year, where mother and son, well actually mother, father and son had agreed to lend money. The parents lent money off the son, and at a hearing the son won the claim. Commercial contracts, there might be a written contract as sorts, to say there's no intention. Obviously it can't be a contract if there's no intention. It could be a case of two business owners discussing an agreement over drinks in a bar. There is a case from 2017, Mike Ashley, the Sports Direct owner, Mr. Blue offered to increase the value of shares in the company, and if he did so, it was agreed over a few pints that Mr. Ashley would pay him a sum of money. Mr. Blue carried out the obligation, increased the value of shares, but Mr. Ashley refused to pay. Mr. Blue sued Mr. Ashley, and Mr. Blue failed. Drinks certainly don't help. It was an agreement, there was no seriousness in the agreement, and it was held there was no intention to create a legal relationship. Be careful. Privity of contract applies to all contracts, and unless there's been compliance with statutory legal requirements, or in some rare situations, only the parties to the contract can enforce the terms or claim benefits under the contract. For example, going back to 1861, Tweddle and Atkinson, the father and future father-in-law agreed that they would pay money to the bride and groom. Before payment was made, both fathers died unfortunately, and the groom tried to claim against the estates on the basis of the agreement. But the groom was not a party to the agreement, he was only a beneficiary, so he could not sue, and his claim failed. Similar case in Beddick and Beddick, 1968, where a husband in poor health agreed to sell his business to his nephew, on the understanding that when the husband died, the nephew would pay a weekly sum to the wife. The nephew did pay once, but never paid again, and the wife tried to sue in her personal capacity, and that claim failed, as she was not a party to the contract. She was, however, the husband's executor of the will, and the wife was successful in a different type of claim for specific performance. So on a personal note, she wasn't able to sue, but she was able to get her money eventually. There are some exceptions under law, including road traffic accidents. Victims can claim against the insurance company. Obviously the insurance contract is between the insurance company and the driver, or the at-fault driver, while the victim could be a pedestrian or a non-fault driver. There's also a piece of legislation where married women can claim against their husband's life insurance policy. Other examples include cases regarding trusts or land, and they are beyond the scope of this presentation. Coming on to the last subject of varying a contract, and essentially it is impossible. There should be a new contract made, or at least a fresh consideration, so there might be a number of contracts arising from the first one. Giving an example, a real life example, and if those of you have caught up with my other presentations, I've used this example before. The case of a barrister and a solicitor, where the barrister had agreed to carry out work for £1,500. The solicitor told the barrister not to start work until the barrister had sent an invoice and the invoice was paid. The barrister agreed to those terms, and that created a binding contract. The barrister then sent new terms a few days later, saying that payment would be due within 30 days and that he would commence the work. There was no acceptance by the solicitor. Remember, acceptance by silence is not acceptance. The barrister did the work and sent an invoice. The solicitor did not pay, and the barrister sued the solicitor and lost the claim. There was a binding contract on the terms that the barrister had to send an invoice and wait for the invoice to be paid before he started work. The new terms, stating that payment would be made within 30 days and that he would commence work, were not binding on the solicitors, and the barrister lost. And it was a small claim, and because of his unreasonable conduct, had to pay the solicitor's costs. In summary, if there is fresh consideration, there can be variance of a contract. Think back to our £100 debt, where there is an offer to pay £50 and additional services offered like car cleaning. That would create a new contract with fresh consideration. That's the end of the presentation. You can visit our website for some potential more information. Or if you've got any queries, feel free to contact us by email, telephone, or you can make appointments with us for free initial consultations online. Feel free to drop by if it's safe to do so. Please subscribe for more presentations and follow us on social media. If this has helped you, feel free to leave a testimonial on Trustpilot. Thank you.